Welcome, everyone, to our wonderful opportunity we have tonight with Tim Williams to learn more about guardianship. I know many of you have participated with this before. Some of you, this will be the very first time. I know that we've had some significant changes in guardianship in the last little while, and we appreciate Tim taking the extraordinary amount of time that it took to develop this new presentation so that we are able to be up to date and understand what is ahead of us in terms of guardianship in the future. What we would like to do tonight, because we have a number of people participating, is Tim will stop occasionally and see if there's any questions. We'll be addressing the questions in the chat later. And after he's completed this presentation, we will stop the recording so people have the opportunity to talk with Tim and ask more specific questions that are more personal. So let me introduce our wonderful speaker tonight, Tim Williams, who has been a previous board member for PC2. He's the person on the other end of the line that I call regularly and say, oh, Tim, I need help. Please help me understand this. We've got a family that needs this question asked. He's an amazing community partner with PC2. He comes from a really interesting background. He was originally a special education teacher, so he understands individuals with differences. And he also is committed to helping make sure that they have the quality of support that they need from a legal perspective. So he later went on to law school and has been a practicing attorney for I don't know how many years. He keeps telling us that it's coming close to not taking new clients, but we beg and other families beg, and somehow he manages to keep going. So we appreciate that. But welcome, Tim. Thank you so much for being here tonight and being willing to share this information with us.
Well, I'm happy to do it. Anyway, this is Guardianships and Conservatorships. It's the third of a series of seminars that we've been doing for PC2 actually for many years. If you want to learn more about the estate planning or the special needs trust able account things, those are available online through PC2. But this is the last one. We probably will be getting together in the spring, but it's the last one for now. And as Beth Ann said, it is a major rework because the law changed significantly last January 1st. And so there have been a number of changes. I'm going to walk you through them. So next slide. As Beth Ann mentioned, I'm a parent. I've got 4 kids and 8 grandkids. None of them has a disability, very thankfully. I am an attorney. I've been an attorney now over 25 years. I'm a teacher. I'm still a teacher. I was a special ed teacher for 23 years, taught all levels of special education from developmental to the mild, and also taught out at Rainier School for a year. I am a former guardian ad litem, and there are still guardians ad litem out there, but the new law has changed the vernacular to, in the guardianship context, to a court visitor. I put down my biases and my philosophy in the sense that I do come to this as a teacher and as an attorney and not as a parent. Washington is very protective of individual autonomy. Everybody looks at disability in a little bit different way, and everybody is unique. And I think it's important that we honor that and let families do what families need to do. Next slide. I am an attorney, so this is my disclaimer. This is not intended to be a substitute for legal advice. If you have an individual problem, you really need to see an attorney about your individual problem. I will be available at the end of this presentation for some discussion of your individual situation if you need it, but it's necessarily fairly minimal and does not create an attorney-client privilege with us. Next slide. So what is a guardianship? Now, the focus of this presentation is on guardianships for those with developmental disabilities, but the laws, regulations, procedures are applicable to all guardianships. When I do this presentation for attorneys, I call it fitting a square peg into a round hole, because most of the guardianship laws were not designed for the developmentally disabled. They were designed for the elderly disabled, who were once able, may have many assets, and now struggle with making decisions and hadn't done sufficient planning to take care of that. So a lot of what happens in the guardianship world don't make a lot of sense for people who have developmental disabilities. Next slide. We'll start with some common terms. Respondent is an individual for whom appointment of a guardian is sought. All right, we used to call this the alleged incapacitated person or the ward, but now we're calling it the respondent. We sometimes also call them a person or adult subject to a guardianship. And in many of the forms we see, it's just going to talk about an adult out there. There's a court visitor now who is an investigator, what we used to call the guardian ad litem. And we'll be talking about both the RCW, Revised Code of Washington, and about the WAC, the Washington Administrative Code. Those are the rules by which we have to play with. The next slide, we're fine. Under Washington law, once an individual turns 18, they're presumed to be a competent adult. Some individuals welcome this. They can't wait to be 18 and be out on their own. I have my oldest grandchild, just turned 18 this summer. He's now in the Navy. He can't wait to be that. But others, not so much. Many resist that. They don't want to be an adult. They don't want the adult responsibilities. And some are not competent to have adult responsibilities or to make adult decisions. Next slide. So the law was extensively changed, took effect January 1st, 2022, so not quite a year old. Part of it took effect a year before on minor guardianships. Is really upended the world of guardianships. Next slide. RCW 11.130 is the new guardianship statute. You can look for it online and see what the law is yourself. Next slide. So I want to start with this intention from the legislature. And one of the reasons for this is that when they changed the law, they left this out initially. And we in our, we who practice in this area really encourage them to include this, because I think this is a very important statement. It is the intent of the legislature to protect the liberty and autonomy of everyone and to enable them to exercise their rights under the law to the maximum extent consistent with the capacity of each person. For those of you that know your history, you know that that has not always been the case for individuals with disabilities. Next slide. And I'm not going to read all of these things for verbatim. Some people need to have their basic needs assisted with. Next slide. Liberty and autonomy should be restricted through guardianship or conservatorship only to the minimum extent necessary to adequately provide for their own health or safety or to adequately manage their financial affairs. Next slide. So a determination of incapacity, that is, whether or not you need a guardianship, is a legal, not a medical decision. If you don't have a court that says that you can't make your own decisions, then you can make your own decisions. It's based on a demonstration of management insufficiencies over time. Age, eccentricity, poverty, medical diagnosis alone are not sufficient to justify a finding of incapacity. This, in fact, has always been the law. This part did not change with the new law. And in fact, they have clarified some of the things that are necessary to find a guardianship. We'll get into those. Next slide. A guardian is appointed when an individual has a significant risk of personal harm based upon a demonstrated inability to adequately provide for their nutrition, health, housing, or physical safety. Next slide. A conservatorship used to be called a guardian of the estate. We used to call a guardian of the person. For this presentation, I'm going to use the term guardian pretty much all the time. It's going to include conservator, but for most individuals with developmental disabilities, they don't have an estate. They don't have money that needs to be conserved. And so for the most part, we don't do a conservatorship. We do just the guardianship. Next slide. Now, what is a guardianship? When someone, because of a disability, cannot handle their own decisions, then the power to make those decisions is removed and placed in the hands of a guardian. It must be the result of some disability, not just bad judgment. If it was based on bad judgment, we might all have guardians, because every single one of us has done something that use bad judgment. That's how we learn. It requires some demonstrated harm, but we can reasonably infer much of that harm. Once you do a guardianship, the court retains jurisdiction. They don't give you a guardianship, give you a letter of guardianship and send you on your way. There's ongoing requirements, and they retain complete jurisdiction over the guardianship. Next slide. So this actually, I think, has always been the case, but they have codified it now in RCW 11-130-265, a three-pronged test for determining whether or not somebody needs a guardian. Next slide. First prong, the respondent lacks the ability to meet essential requirements for physical health, safety, or self-care because they are unable to receive and evaluate information or make or communicate decisions, even with appropriate supported services. Okay, so the first prong is they lack the ability to meet their own needs. Okay, often people think, gee, that's all you need to have a guardianship. Not so. Next slide. Also must be necessary to prevent significant harm or risk of significant harm to physical health, safety, or self-care. And for a conservatorship may be to assets. So not only must they have the inability to completely manage their own affairs, there must be a significant risk of harm. And the third prong, next slide. The respondent's identified needs cannot be met by a protective arrangement instead of a guardianship or other less restrictive alternative. Next slide. So to recap that, because it's very important, lacks ability necessary to prevent significant risk of harm and no less restrictive alternative. This may be counterintuitive, but often it is the case that the more disabled you are, the less you need a guardianship. I want you to think about that for a minute. Why is that? One of the very first cases that I took as a guardian ad litem happened to be up in Kitsap County for a very disabled young man. He could do nothing for himself. He couldn't dress himself, he couldn't walk, he couldn't talk, he couldn't feed himself. He was cared for by his mother and his grandmother. And they thought they needed to have guardianship. They'd had many people tell them, oh, your son is really disabled. He needs a guardianship. Well, he certainly lacks the ability, meets that first test. But was a guardianship necessary to prevent significant risk of harm? No. Over the dead body of mom and grandma was anybody going to harm this young man? He was always in their care. Nothing was going to happen to him. Everything worked very well. And in fact, there were a number of less restrictive alternatives to guardianship, alternatives that we're going to be talking about tonight, that made it not necessary for him to have a guardian. I'll contrast that with a relatively mildly disabled person who has good verbal skills, has some employment skills, but lacks the judgment to truly go out there and be fully functioning in society. Bill Dussault, the father of guardianship law in the state of Washington, tells a story about a number of his clients who went to an event at the Bellevue Mall, and they were handing out credit card applications. And these girls were out there having a great time, and they filled out those credit card applications. And son of a gun, if they didn't get credit and all of a sudden they had free stuff, they were very happy to do that. A guardianship may in fact be necessary to keep that sort of thing from happening, or to fix that once it has happened. They're at much greater risk. People who have enough ability to be out and about in the community are also much more vulnerable. Next slide. There we go. Once you become a guardian, you have certain duties. You have to report to the court within 30 days of any substantial change in their condition or residence. I get phone calls infrequently from clients who move, and I will call them and find out that they've moved 6 months or a year beforehand. No, the court wants to know right away. You're to care for and maintain the respondent in the setting least restrictive to their freedom and appropriate to their personal care needs. You're to assert their rights and best interests. You are not required to be the caregiver for somebody for which you are guardian. And in fact, there are many guardians out there whose children don't live alone, and many professional guardians who do not care for the respondent. But you do have an obligation to make sure that they're receiving good care. Next slide. You are a fiduciary when you are acting as a guardian. Fiduciary is a legal term meaning that you shall not substitute your beliefs for that of the respondent. You have an obligation to promote self-determination for the respondent. You are to exercise reasonable care, diligence, and prudence. You may handle some finances. You make decisions that the person would make if they were competent or in their best interest. And these are your standards found directly within the statute. I come across a number of people who come to me for guardianship. They're getting SSI for their children. They're the representative payee. they put it all into a single pot, not being a fiduciary. When you do that, you have an obligation to keep their funds separate and to account for their funds. It's important that you're aware of many of those duties. Next slide. A conservator happens when an individual has a significant risk of financial harm based on a demonstrated inability to adequately managing their property or financial affairs. This is one area where I think the law has changed a bit. We tend not to appoint a conservator unless there really is a substantial estate. Next slide. When you are a conservator, you have an obligation to inventory the estate, protect and preserve the estate, invest in and reinvest any assets that they have, apply to the court for payment of bills. Does not mean you have to go to court every month to do that, but you have to set up a budget and you have to have a plan in mind and report to the court periodically. The new statute is not as specific as the old one, but the tasks are similar. Next slide. Notice requirements. There are significant notice requirements for many guardian and conservator duties that are not relevant to the developmentally disabled population, and they're not covered by what I'm doing here. However, I want you to be aware of them in case you're familiar with guardianships in another context. That what we're doing here is talking primarily about the developmentally disabled. One of the reasons I mention that is that if you're a guardian for an adult who has a spouse or children, they become automatic notice parties, and it complicates the whole process significantly because almost everything you do has to be, you have to give notice to those people. Next slide. So who needs a guardianship? There is no legal requirement to have one. That comes as a surprise to a lot of people. There are many disabled who live without the benefit of guardianship. I have many clients who are living with, sometimes even no longer living with, their very disabled children. Children who cannot manage on their own, who are living in some sort of supported living or at home or in a group home, but who do so without the benefit of a guardianship. Again, while it may be counterintuitive, the more severely disabled you are, the less you may be in need of a guardianship. It does act as a kind of insurance policy. Next slide. So you want to be thinking about why you're looking at a guardianship now. I get a lot of phone calls from people whose kids just turned 18 or about to turn 18, who have had schools tell them or doctors tell them or somebody else tell them, oh, your child is disabled, you have to get a guardianship. Not true. Just because they turned 18, nothing bad is going to happen just because they turn 18. They are still going to be managed very successfully without a guardianship in many, many cases. You want to think about how the loss of autonomy will affect the respondent. What do I mean by that? Well, once we take away their ability to make decisions, they don't have to make decisions. They don't learn from those wrong decisions. That will have absolutely no impact upon somebody who is completely nonverbal and doesn't understand what a guardianship is in the first place. But for a relatively high functioning autistic or other developmentally disabled person, it can have a significant effect, a non-normalizing effect. And you should be thinking about that because probably nobody else in the system is going to be thinking about that. You want to be thinking about the time and the cost it's going to take, because all of this is going to take your time and it's going to cost you money that you may have better uses for. Are there alternatives? There are, and we're going to talk about them. I believe, and I've always recommended this to my clients that it needs to be a personal and family decision, not a teacher decision, not an attorney decision, and ultimately not even the judge's decision. You need to make the decision whether or not guardianship is right for your family. And it needs to be a well-considered decision, knowing all the benefits and problems that can come from having guardianship. Next slide. So some common reasons for guardianship: medical care. If your child is medically fragile, particularly if they're receiving care from Children's Hospital in Seattle, you may need a guardianship. For whatever reason, Children's Hospital in Seattle seems to think that a guardianship is always necessary. Don't have that problem with Mary Bridge or other hospitals in Pierce County or in other parts of the state. It's very, but sometimes it's easier to get the guardianship than it is to fight the medical care system. Dental care. I have many clients who have really good medical care. They've got a good relationship with their doctor. They don't have a problem. They don't need a guardianship for that. But I have a number of clients who find it really easy to go to the doctor and really difficult to go to the dentist. They don't want anybody in their mouth. It can be a very scary kind of thing. And there are not that many good dentists that accept Medicaid for care. So I have a number of clients who have had over the years significant health issues related to their dental care. And sometimes we have to start a guardianship for that. Contact with the legal system, either as a victim or a perpetrator. If you've had contact with the legal system, or you're likely to have contact with the legal system, you probably need a guardianship. Guardianship is going to be of limited value for you. I'll tell you that up front. It is not going to magically make all of a sudden everybody's going to talk to you now. It's the criminal justice system does not deal well with individuals with developmental disabilities. It just doesn't. It's getting better at it, but it doesn't do it well. If you have a guardianship, you will have your foot in the door. You will get some people to talk to you and allow you to help them make decisions. Without the guardianship, you will be systematically excluded. Often we start a guardianship for when they're moving out of the family home, moving to a group home or adult family home into supported living. Not always the case, and in fact, becoming less so. Is there demonstrated harm out there? Do we already have somebody who's been abused? I've had clients who at one point in their life were both financially and physically abused by often the family of, or actually a romantic partner of some sort. Passport. If somebody can't sign their name, it may be difficult to get a passport. So if you want to get a passport, take somebody out of the country. You may end up needing a guardianship for that. I've had a couple of reports of that. Sometimes DDA or DSHS believes for whatever reason that you should have a guardianship. Sometimes that's because they're not well trained. Sometimes it's because they've got some ideas that you need to pursue. Next slide. Privacy Act considerations. Even an adult child, if they're unable to make their own decisions, there is an informed consent statute, RCW 7.70.065. And I have many clients who use this with all of their medical providers. As a practical matter, parents will continue to have an apparent common law right to make these decisions regarding adult disabled children. And if an adult child is capable of understanding the basics of a power of attorney, this also can be an excellent alternative to guardianship. So we can continue to make decisions for the adult disabled through a couple of these methods. Next slide. Education. Can schools talk with non-guardian parents? I often get people who say, oh, my teacher says that I can't even be at the IEP. Wrong. That's not the law. First of all, parents retain the right to access records of any student who is dependent under federal law. And dependency is just like if they're living at home and you're paying for their care, they are dependent. And so you automatically have access to records. Parents can also provide consent on an IEP. And again, the informed consent statute works for other medical care and for some educational care. Next slide. Giving you a reference to IDEA for those of you that are familiar with the Individuals with Disability Education Act. This is the federal statute. The state has established procedures for appointing a parent of a child with a disability, or if the parent is not available, somebody else to be a surrogate decision maker for anybody who is unable to make their informed decision, educational decision. I often ask my clients if they're having a problem with the school system to go to the IEP meeting and look around the room and say, does anybody in this meeting think that my child can make an informed educational decision? And if they can't, then they have to appoint somebody. Now, there's a process for doing that. You have to get some verification of that from some medical professionals, but it's relatively easy to do, very common in this process. Next slide. I give you the specific WAC. You can go and take a look at the WAC. It does require a statement from 2 separate medical personnel, but a parent is presumed to be the educational representative. The WAC says that it must be renewed yearly. My experience is that once it's done, it tends to be done. But you can make sure that your school district knows that you still get to make those decisions. They should help you through that process. Next slide. The new statute does allow the guardian to establish an adult's place of dwelling. This is a big change in the statute. The last statute did not. There are some specific criteria for doing so, but I think it does give the guardian a little bit more power to specify where the person's going to live. Next slide. What can't a guardian do? There are some misperceptions about what you can do as a guardian. Next slide. One of the things that is very difficult to do is restrict contact with people that the respondent wishes to be with. This is actually one of the reasons why the statute was changed, is because there were a number of adults out there who had a guardian, and the guardian was restricting who the respondent, often their parent or somebody close in relation to them, was being with. I have some developmentally disabled where it is really important that the guardian be able to restrict who that person can be around. But there's a lot of language and a lot of hoops that you have to go through if you're going to do that. You can't just do it. Next slide. Right to refuse antipsychotic medicine. Doesn't happen often with the developmentally disabled population, but it does. And so you have to be very careful about what you're forcing somebody to take. There must be a serious attempt to make a less intrusive course of treatment than medication before you can actually use that. Next slide. Modification of a guardianship. Actually, when I started doing this 25 years ago, most guardianships lasted for the whole life. Over the years, we have dismissed a number of guardianships, and it's getting a little bit easier to do so. There's now a specific procedure under the new statute. All things having to do with guardianship, the court has broad authority to do anything it believes is in the best interest of the person subject to the guardianship. Next slide. But there's a major change in the guardianship, which is what we call a burden shifting change. It used to be that when we thought, gee, a guardianship no longer was needed, we had to prove to the judge that it was no longer needed. That's a heavy burden. Now you must reprove that it's necessary to keep the guardianship. The burden is shifted. This may sound like a minor or technical shift, but it actually is quite significant. Next slide. And transferring a guardianship from another state or transferring from Washington to another state is also specified in the statute. That's been part of the statute for some time. We used to think that might make it a little bit easier. It tends to take about the same amount of time and money as it does to actually start a guardianship, but it is necessary to do. Next slide. Actually, before we get here, let's see if we have any questions. Anybody have any questions that they want to bring up now? I'm not seeing a chat, so I don't know whether anybody has put something in the chat.
Tim, right now, there are no questions in the chat. I will scan through to see everybody. And if you have a question, if you want to raise your hand, and you can do that by just physically putting yourself on camera and raising your hand, or you can raise your hand with the reactions at the bottom. And right now, I don't see anything. I'm sure we'll have plenty of questions when we're finished with recording.
All right. So let's talk about some of these alternatives to guardianship. One of the most common one is a power of attorney. Power of attorney is something we all should have. I have one, and every one of you should also have one. A power of attorney does not delegate authority. It designates an agent. It never, ever takes away the power of the individual who's signing the power of attorney. We call the person who acts as often say I'm acting under a power of attorney, but the actual legal term for that is attorney in fact. They are always a fiduciary. They always have a high duty to represent that person with the utmost honesty and openness. The disabled person has to have enough ability to typically sign their name and understand what it means to designate an agent. That's actually a relatively low standard, and a power of attorney works for many of my clients. It is not particularly protective, but it does allow a parent or some other family member to advocate and represent that person in other contexts. Supported decision-making. That is a brand new part of the law. It was supposed to be an alternative. I actually have had recent contact with somebody who did a supported decision-making agreement. They did also a power of attorney at the time, and I think that a power of attorney is actually a bit more powerful. It works really well for people who are suspicious of powers of attorney, or suspicious of somebody coming in and making decisions for them. Many people in our disabled population have been abused and have had somebody really take things over inappropriately for them. And so they don't want that to happen. And so they get a little bit skittish about doing a power of attorney, and supported decision-making may be very appropriate for them. A limited guardianship. I have always advocated for a limited guardianship. The trend is to make that even more so. We have a list of things, and I think I've got it in the materials to we can just take away those rights that we really need to take away. If we need to deal with money, special needs trusts or an ABLE account is a really great alternative to either guardianship or conservatorship. And you, in fact, can do nothing. And I have many clients who do this. They're the representative payee for any money that comes in, whether it's SSI or Social Security disability, and the consent to healthcare statute. I find that many people think they need a guardianship to get their SSI started. Not true. I've had many clients who've been able to assist their children in that process. There are a lot of things that happen when somebody turns 18 that make it difficult. One of them is that all of a sudden they may be changing healthcare insurance plans, and the insurance people don't really understand disability. If you can get them over that hump of dealing with somebody other than the individual, it works pretty well. Power of attorney can go a long way if they can't sign a power of attorney. Sometimes just getting them physically present with the person making the decision makes it very clear that they need to have somebody who can do that, and you don't need a guardianship to do that. So that's always an option. Next slide. Power of attorney, very powerful. Give someone else the power to do almost everything you can do yourself. It is always supplemental, and it usually avoids the need for a guardianship. Next slide. Must have sufficient capacity to understand and communicate what it means to have someone to act as your agent. Next slide. Supported decision-making. There's actually some forms in the statute for doing this. If that sounds like something you might be interested in doing, there's a lot of resources out there. This is used more extensively in other states right now. We're still learning about it here. Next slide. Best used for high-functioning individuals with disabilities. For most people with significant developmental disabilities, it does not appear to be a good option. Next slide. Limited guardianship. It is favored in public policy. It's not used often enough. Next slide. Here are some of the things that you can address in this process and either leave them with the respondent or take them away. Right to vote, right to marry, consent to or refuse medical treatment, to decide who shall provide care and assistance, who's going to make decisions regarding social aspects of their life. That is, who can they hang out with, to possess a license to drive. Next slide. Make or revoke a will, enter into a contract, appoint someone to act on their behalf, to sue and be sued other than through a guardian or conservator, to buy, sell, or deal with property, and to manage their money. Sometimes we can take away their ability to manage most of their money and leave them with the ability to manage a little bit of money. That's not appropriate for everybody, but is appropriate for many. Next slide. There seems to be less of a need for a conservatorship under the new law. So that's one of the things that we're doing more and more, which is not doing a conservatorship, but just doing the guardianship. Be creative in your process. You're the one who knows the disabled person. We don't. Next slide. Special needs trust. I did a whole program on special needs trusts and able accounts last week. Just to briefly go over it. If they have some asset, if they come into some asset some way or another, you can put that money into a special needs trust. Next slide. There are two basic kinds of special needs trusts, what we call a first party trust and a third party trust. It is a complex and changing area of law. And if you think you need one, I'm happy to talk to you about it, or there's a number of attorneys out there that can do that. Next slide. Able account is another new option for assets. You must have been disabled prior to the age of 25, and it is restricted to $17,000 a year or less. That's a new, $16,000 actually this year, going up to $17,000 next year. If you're interested in learning more about able accounts of special needs trust, you can get the materials that I did last week from PC2. I also have a lot of material on my website. Next slide. Representative payee. I think most of you probably know what it means to be representative payee. You can be representative payee for Social Security benefits, but you can also be representative payee for other benefits that may be coming to an individual. Next slide. And the informed consent statute, again, a very powerful tool to use to make medical decisions, and I think also other decisions. It provides a hierarchy of individuals. It starts out with a guardian. And if you don't have a guardian to your power of attorney, your attorney in fact, if you don't have an attorney in fact, and you are married, then your wife gets to make, or your husband gets to make that decision. Most, but not all of my clients are unmarried. After spouse, it goes to children. Some of my clients have children, most do not. But if you have adult children, they can make that decision under the informed consent statute. Then it goes to parents, and then it goes to siblings, and then it goes to other people in your life. And it's a very powerful tool that has worked for many, many people. Next slide. Who can be guardian? Used to be some statutory requirements. They have been taken away. Although the court retains plenary authority and will likely continue to review criminal and bankruptcy history, you do have to disclose your criminal and bankruptcy history. Plenary, good legal term. I like to throw in a couple of legal terms in my presentation. Plenary just means that they have all-encompassing authority, just everything having to do with it. It's pretty well not limited. Next slide. Can a guardian be paid? Courts must allow reasonable fees to be paid to the guardian, and in fact also to the attorney for the guardian. Paid by, I didn't change the slide yet. I put IP, which is the old term, paid by the respondent. Professional guardians deserve to be paid. Parents and other family members usually do not request payment, but they can be paid. Next slide. Oh. We'll get rid of that, and we need to let me go back a slide. Actually, I'm thinking I have another slide on how to do that. So let's go ahead and move on. The liability of a guardian, you are a fiduciary, so you have to manage people's money other people's money well. I often describe this as, and I have many clients who don't balance their own checkbook. Nobody requires you to balance your own checkbook. But when you manage somebody else's money, you've got to balance the checkbook. For most of my clients, that's not an issue. For some of my clients, balancing a checkbook is a real struggle. Court retains jurisdiction, and they're going to be looking at what you're doing. The guardian is not financially liable for the debts of the respondent. They're also not obligated to provide housing, but they are held to a reasonableness standard, so that you've got to act reasonably. And if the respondent, the person subject to the guardianship, the adult subject to the guardianship, is in a position to do harm to somebody, either to an individual or to property, you have some responsibility to manage that. Doesn't mean that you got to pay for it if they wreck something, but it does mean that you have some responsibility there. Next slide. Bonding. Bonding is a big deal for the court. If you're going to manage money, the court is probably going to require that you have a bond. A bond is just paying money to a bonding company that if you walk off with somebody's money, they're going to come in and they're going to give it back to them. Court will look to income as well as assets when determining whether or not bonding is necessary. Most guardians do not have to post a bond. Most conservators, in fact, do have to post a bond. You may be disqualified for inability to be bonded. Bankruptcy does not automatically disqualify you. Next slide. So who pays the guardian? The guardian is paid from the respondent's assets, okay? The state does not pay for the guardian. But if the respondent is on SSI or on Social Security disability and is receiving services from DSHS, there may be funds available to pay both the guardian and attorney fees. Otherwise, there may be nothing to pay the guardian or the attorney. And I'm not going to tell you that the process makes any public policy sense, only that if the individual is living at home, there's no money available. If the individual is in supported living, there's no money available. If the individual, however, is living in an adult family home or a group home, they're probably paying participation. And in fact, their participation can be reduced so that they have the money to pay a guardian and a guardian's attorney. There's some restrictions on this, but it is relatively common to do that. So there are some options out there. Next slide. The guardian must keep careful records of time spent, usually in fractions of hours, costs, keeping receipts, any other expenses. So if you're going to be paid as a guardian, you've got to keep good records. You're not paid a salary. You don't get $275 a month to do it. You got to get a reasonable hourly wage and keep records of your time. Next slide. So we're going to start talking about the process. So I'm going to stop it here for a minute and see if there's any questions.
Tim, we have questions in the chat. Would you like to go to those now?
Yeah, I can see the chat now.
Okay, I can give them, I can read them to you. Hi, Tim. Can you please comment on how divorced parents with dual custody address guardianship for a child whom they are permanently, that's all I can see of the message.
Are permanently disabled. No, I've got that. I have had many clients who, actually I've had many clients who started out married and ended up getting a divorce. And that's always a struggle. I have had people who have started guardianships because they were divorced, because the other parent and they did not get along or did not have agreement on what was happening. I have one client who is co-guardian with a divorced parent. That works, sort of, and I'll just leave it at that. Co-guardians are not generally a good idea, except for married couples who really are together. And then co-guardianship works very well. Other than that, co-guardians generally does not work particularly well. Custody ends at age 18. So you no longer have a custody agreement for an adult. And sometimes you have to start a guardianship to sort of continue just because of the rancor that exists between two parents. I will tell you that for most of my clients, the parents, even when they're divorced, come together and have the interests of the person at heart. So that works out pretty well. Does that answer your question, Marilise?
Thank you, Tim. Yes and no. I'm in a very contentious divorce situation, so and my ex will not have me take over guardianship.
So
So,
this
it's
would
a bit of a, that's it. Yeah. So this is a bit of a private thing, probably.
Right. I think that would be a private conversation. Mhm.
What is the cost for a guardianship? I will talk a little bit more about cost later on. Do I offer individual consultations? I do. You're welcome to call me. Are POAs all done through a court judge approval, or are they just signed by all the parties in front of a notary? That's an interesting question. First of all, no, generally a court or judge does not need to approve of a power of attorney. And the only one who needs to be there is the person, what we call the principal, the person who is designating somebody else. So even the person who is accepting it does not have to be there. You obviously want to have asked them and make sure that they agree to a power of attorney. But it does need to be signed in front of a notary. I do that. Not all attorneys do powers of attorney, but many of us do. And you can also get a power of attorney. PC2 has done some. There are some other agencies out there that will do power of attorney for you. Okay. All right. I will be talking about this. Do you go through an attorney for the guardianship and then to court to get approval? You don't have to have an attorney to do this process. And there are people who do it without an attorney, but a court is always necessary at every step of the process. The court is going to be necessary to get it started. The court is going to be necessary in an ongoing basis. And that is all I see in the chats right now.
Yes, Tim, I think that's it for right now.
Okay. So let's talk about what's the process. Well, the first thing you have to do is to take the guardianship training. In fact, let me back up a step here. We have, I don't know, 40 some odd counties in Washington. Guardianship process is governed by state law, and it's very different from state to state. But the actual nuts and bolts of how we get there is actually quite different from county to county. It hasn't always been that way, but with the new guardianship law, it has seemed to work out that way. And so particularly in the big counties here in the I-5 corridor, Snohomish County, King County, Pierce County, Kitsap County, Thurston County, you find some significant differences in how they go about doing this. Most of the things that I will talk to you about will be generally true in every county, but it's the actual nuts and bolts of how it works can vary considerably. So the first thing you're going to do is take the guardianship training. Training, you say? I've got to be trained to do this? Yes, you do. King County, I think, has its own training, or they used to. The state is running a guardianship training. It's online, takes an hour and a half to 2 hours. It's not particularly intuitive. I tell my clients that it will tell you a lot of things about guardianships for the elderly that you will have no use for, a lot of things about conservatorships, but you still have to do it. It is free. It is not required that you have the training before you file the petition, but it's a really good idea to do that. Then you're going to file a petition for guardianship. There's a filing fee. It's actually $240, which is the same across every county. It's an extra $1.50 if you do it online, which I typically do. This fee may be waived if your child has no money, and most of my clients don't, less than $3,000 in assets. So we can waive this fee. A court visitor is appointed. The respondent must be served with notice. Now, for those of you that have been involved in a lawsuit before, which is probably not many of you, when you start a lawsuit, you have to serve the other party. There are process servers out there who will do that for money. This is a legal process, and the respondent must be served, and anybody can serve them, wow, except you. So you get another one of your 18-year-old or older children, or a neighbor, or a parent or grandparent to come in and give them the document so that they are served. A hearing must be held. Guardianship law is unique among the laws in Washington. If I want to sue my neighbor because I think their tree is dropping too many leaves in my yard, and then I discover that, oh, that's not really something I can sue them for, I can take it back. I can withdraw it. If I want to sue somebody for divorce, or I want to sue somebody for damages, and I change my mind, I can withdraw that suit. That is not true in guardianships. In order to withdraw, you must get a judge to agree with that. Why is that? Well, because once you start a guardianship, you are putting the court on notice that there is a potentially vulnerable adult out there that may need help. And the court is obviously concerned about that. So you can't just back up and say, oh, I don't think that's a good idea. It may be that, oh, you didn't think about that power of attorney and you may need to withdraw it, but a court has got to agree to that. Next slide. Court visitor, there's a list in each county. They arrange for a medical report. They must have seen the respondent within 30 days, and a visitor report must be filed at least 15 days prior to the hearing. That actually is waived fairly frequently, but we can make that happen if we need to. Next slide. The primary questions for the court visitor are, does this person need a guardianship? Are there less restrictive alternatives? And they're going to be discussing that with the respondent and with the people close to the respondent. They're also going to be asking, is the proposed guardian qualified? Is the proposed guardian the most appropriate person to do this? When you are talking about a divorce, I get questions frequently about, gee, I've got a divorced couple, they share a special needs child. and they're worried, one of them comes to me and they're worried that the other one is going to rush out and file for guardianship. The court's visitor job is to make sure that just because you're the one to petition for the guardianship doesn't give you a head up on being the guardian. You may not be the most appropriate guardian. The other parent may be, or somebody else may be. So you don't need to worry quite so much about whether or not you need to be the first in a contentious case. But it is important that the visitor evaluate that. They will make a decision. Next slide. They will explain the petition to the respondent in the manner that they can best respond to it. Some of my clients can understand it fairly well. Many don't have any understanding of the legal process at all. They're going to ask if they want an attorney. That attorney will be appointed at county expense if requested. They may use their own attorney. I was just informed that in King County, they appear to be appointing an attorney in every case. I don't think that that's legally necessary, but that seems to be what they're doing. It asks if they want a jury trial and requests and reviews other documents. Typically, for most of my clients who have been through special ed, they're going to be looking at a district decision, at the psychological, and an IEP. Sometimes there's extensive amount of outside testing that's been done that can be very helpful to the court visitor. Next slide. Who appoints the guardian? A judge or a commissioner? Now, you may not know the difference between a judge and a commissioner. In small counties, there are many counties in the state of Washington who only have half a judge. A judge splits their time between a couple of counties, and judges are elected in their jurisdiction. So in the county they are. In larger counties, we have 23 judges in Pierce County, and I think there are 30 some odd judges, maybe even 40 judges in King County. They are very busy. And so the judges hire commissioners to do a lot of routine work. And starting a guardianship is considered relatively routine work. So in Pierce County, a commissioner will do the initial work of getting the visitor appointed and the initial appointment of the guardian and of the other initial hearings that are required. After that, in Pierce County, the judge will do the annual reporting. In other counties, sometimes the commissioners keep that as part of their responsibilities. Next slide. A hearing must be set within 60 days. It may be dismissed if timelines are not met. It can be continued for good cause. The most common reasons for it to be continued is that it's taken us too long to get the medical report, or the court visitor is a little slow and hasn't been able to get the report out, or that it's contested. And in fact, it can be contested. Not very unusual for the developmentally disabled, but it has been. And that just means that the person doesn't want a guardian, doesn't think they need a guardian. Next slide. Post-hearing process. You need to file an acceptance of guardian, used to be called the oath. You have to file a bond if there is a bond requirement, and then letters of office are issued. Next slide. Then we have to provide a notice of the guardianship to the respondent. We have to, within 14 days, within 30 days, we have to give them another notice of a right to contest or modify a guardianship. Next slide. See what I did here. Within 3 months, I need to file a guardian plan, which is sort of my plan of action. What am I going to be doing here? I can't just go out and do it by the seat of my pants. I've got to have a plan in mind. There is now a mandatory hearing required on the guardian plan. This is one reason why Expenses have gone up a bit because of the new law. And notice to the respondent and any other interested parties at least 14 days prior to the hearing. Next slide. In Pierce County, they automatically do it after 1 year. Sometimes you can go initially even to a 3-year cycle. For most guardianships where there isn't a lot of money, you can go on to a 3-year cycle. There's a guardian's report and accounting that you have to file, and then the judge will sign an order approving your report and giving you letters of office for another 3 years. There are forms available on the state court website. I think I have a link to that in my materials. The forms are new and are still a work in progress, so they're not all completely accurate. Hate to tell you that. Next slide. If you're not living with the respondent, you must provide a list of dates that you visited. This is something that is new, and we expect this to take actually a significant amount of time. You got to start keeping a record of making a list of the times you visited with the respondent. If there are notice party the requirements are extensive for making sure they get notice of everything that you are doing. The annual triennial hearing in Pierce County is set by the county. In other counties, you have to do it on your own. And you have to give notice to any interested parties. Next slide. You can all read this. If you've ever dealt with an attorney, that is a standard attorney answer to any question you might ever ask. If you have not had to deal with an attorney, lucky you, but that's probably the answer you're going to get to almost any question an attorney is asked. It depends. Everything is fact specific. There's no legal requirement for you to have an attorney. And many people do it without an attorney. Next slide. What are the costs of guardianship? Now, with an attorney, the initial guardianship is running for most of my clients $3,500 to $4,000. I think I'm asking for a $4,000 retainer. If the individual has money, most of my clients don't, but if they do, they're going to have to pay the filing fee, and they're going to have to pay the court visitor fee. I charge $3.75 an hour. That's a lot of money. But I can do this fairly efficiently. And so typically costs in that neighborhood, $3,500 to $4,000. Annual reporting, I am presently doing that for 3 hours of my time. Presently, what is that? $1,175, I think. I typically take more time than that, but most of my clients really like a flat fee. Other attorneys will do it for less. Other attorneys will do it for more. Who pays this? Unless the individual is in some sort of group home or adult family home, you're going to pay. If they have enough income to do that, that's great, but most of my clients do not. Next slide. All right, I'm going to, other considerations. Your will and other estate planning concerns. I often get people who think they need a guardianship, but what they really need, because I think they can do it without a guardianship, is they really need to make sure that their will and other estate planning things are in order. They need to make sure that they're the representative payee for the individual's income that's coming in. Did I answer the cost question for the person that had that in the chat?
The person answered yes.
Okay.
And so we do have another question. Do you want to wait until we're through, or do you want to take it now? Tim?
We're almost done.
Okay, and then we'll take it at the end.
Sure. Next slide. My conclusion, and I will read this: many individuals with significant disabilities live their whole lives without a guardian. Others may need protection provided by guardianship at 18 and will be harmed by delay. Still others may appropriately defer guardianship for many years, but will ultimately need a guardian. And one thing I could add to this is that a number of people will need guardianships fairly early, but will no longer need them after 10 or 15 or 20 years because they have matured and are able to take over some of those duties. One of the things that I know about people with disabilities is that sometimes they really do mature and really do a good job. Next slide. There are many reasons why a guardian might be appropriate, but each individual circumstances are different and should, in fact, Washington law must be evaluated individually. You may want to contact a legal advisor to assist you in making this decision. Next slide. That's it. Those are the resources. They're available. These slides are available. They're going to email them out to people, I think, here soon.
Tomorrow we'll be sending them out, Tim.
Tomorrow. I'm still reworking my other materials for guardianship. I hope to have that to PC2 by tomorrow, but I'm not going to make that promise yet. So
I'm going to check these two. Okay, these two questions. We've got a question here, and that I think would be generic. I just lost my chat. Just a second.
Okay, I've got this.
You've got it. Okay, you've got it right there. I see it now.
Is it possible to cancel a guardianship? Okay, we don't call it canceling. No, it is not possible to cancel a guardianship, and a guardian does not have the power to do anything other than to bring it to the court's attention. Only a court can dismiss a guardianship. However, guardianships are dismissed, and I think that we're going to see more and more of that. And as I talked about earlier in the presentation, there's really been a burden shift from if somebody in the respondent's life says, we don't think you need a guardianship anymore, and brings that to the attention of the court is really obligated to go through the whole process again of saying, does this person have a disability? Can they, do they lack the ability to manage all of their things? And will they be harmed? And are there no less restrictive alternatives? And if they can't answer all three of those questions, then they're going to have to dismiss the guardianship. I think this is still a learning process for many of the judicial officers, also for many of the judges out there, and they're still working on this. So we're all doing that. Number two, after the parent's death, if the loved one will go to a group home, a guardianship is not required, even under that circumstance. A guardianship may be appropriate. A lot of it depends on what other family support the person has, but it is not legally required. Now, having said that, there may be a group home or a adult family home that will say, we're not going to take you unless you have a guardian. And they have the right to do that. Or there may be a supported living group that says, we're not going to take you unless you really have a guardianship, but that's not a legal requirement. And let me look at the question after this. What is the limited guardianship? We can choose as a guardian's duty among the common reasons like financial decisions and medical. Yeah, I gave you a list in the materials. I'll give you a little bit, and you can see that list once you get the materials of the slides, and I will have a little bit more extensive on the materials I pass out. What I do want to emphasize here, you say we can choose as a guardian's duty. You don't really get to choose. The court decides. You can ask the court for this power to do this. You can ask the court for the person to retain that particular power, but you don't get to choose it. It is a court decision. And then the next question is, how can the court or others control or monitor the guardian? On an ongoing basis, the court does that by making sure you come back after a year, getting a report from you, getting a chance to talk to you, making sure that things are going well. Even on a 3-year plan, the court does that. There is also specific options in the law for anybody to bring to the attention of the court, hey, we think something's not going quite right here. Could be adult protective services, could be a neighbor, could be another family member. They can bring that to the attention of the court, and then it's up to the court to require you to come in court, and they can do that. You have subjected yourself to the court's authority when you become the guardian. As I said at the very beginning, the court retains authority. Sometimes they're thought of as a super guardian for everything having to do with guardianships. And I see there's another message down here.
From Rachel, we have our guardianship hearing was yesterday. Yay. I left my lawyer's office with a guardianship plan, documents to complete. Did I see your slide? Did I see your slide says that there will be another hearing with the commissioner to review it?
That is correct. So I'm starting a guardianship on Friday. We just presented our order to the commissioner to look at. And so once my clients are named the guardian, then we file the guardian plan and set a hearing for 30 days out, serve everybody, give everybody all the appropriate notices. And then there needs to be another hearing approving the plan. So.
Well, we will be taking time to take your individual questions from here. So right now, okay, if this is a generic question, and then we'll be going off recording, and we'll continue with off recording questions. So I want to thank everyone for coming this evening. I would like to remind all of you to please go to the beginning of the chat, and please take time after this to fill out that survey. If we don't have a survey response back from you, we'll probably be sending another one out because we really do want to get your feedback. We will be sending out the materials, and Tim has mentioned a couple of times he has additional materials. So I'd like to thank all of you for coming this evening. Thank you for your questions. And now we are going to discontinue the recording, and we will start some individual questions with Tim.